Hello and welcome to episode 39 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh DeHaas, counsel with the Canadian Constitution Foundation.
I'm Christine Van Gyn, the CCF's litigation director.
And I'm Joanna Barron, executive director of the CCF.
In today's episode, I'm going to talk about the failed attempt by McGill University to get an injunction against the protesters, the pro-Palestinian, anti-Israel protesters who are currently occupying campus.
I'll tell you about a rather disappointing decision from BC's Supreme Court, which ruled that the province's ongoing COVID-19 vaccine mandates for healthcare workers was justified.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But before that, I'm going to tell you about a small victory in the fight against unreasonable vaccine mandates. So the decision is called Union of Postal Communications Employees in Canada Post. And I should note, this is just a labor arbitration decision, so it's not a binding law, but it is a small victory because it found that Canada Post's policy of requiring people to get vaccinated or go on unpaid leave, even if they worked from home and there was no reasonable prospect that they'd be forced back to the office, was unreasonable. And it also said something else that I think is pretty important. So here's what happened. The UPCE are Canada Post workers who do things like IT, human resources, finances, purchasing, and work in a call center. And when the pandemic hit, most of these employees already worked at home some of the time. And during the initial days of the pandemic, 95 to 97% of them were exclusively at home. By the fall of 2021, which is when the Trudeau government announced they would require vaccines for all federal workers and also to board planes and trains, about 2/3 of these workers were still fully at home. And Canada Post was trying to come up with a plan to accommodate workers as they returned to the office without forcing vaccinations on them, while also reducing transmission in the workplace. And they were studying a plan to allow rapid testing as an alternative, which is something that some workplaces did, including some school boards here in Ontario. But according to Canada Post, Health Canada made clear to them that it would not supply rapid tests if those tests would be, quote, used to circumvent the federal government's direction that Crown corporations have mandatory vaccination policies in place. So Canada Post didn't really have much choice, and they said everyone must attest to 2 doses of vaccine or else they'd be placed on unpaid leave. And originally all but 37 of these employees complied, but several of them decided to grieve the new policy, including some who worked exclusively or almost exclusively from home. So since this was a labor decision, the test requires balancing rights and interests of employees against the risks of workplace harm to determine whether the policy is reasonable. And the employer had an obvious interest in protecting the health and safety of employees in the workplace by reducing the spread of COVID-19. But a few previous labor decisions had already found that the individual employees' interest to privacy and their economic interest in their ongoing employment outweighed the employer's interest in protecting health and safety when they worked mostly from home. And a fourth decision, which was called Williams Lake, also found that these policies interfered with bodily integrity, which is the right to be free from physical or serious psychological interference. So the fact that this decision found that Canada Post policy of requiring even fully remote workers to be vaccinated was unreasonable isn't novel and maybe not all that interesting. But what is interesting is that Canada Post claimed it had a, quote, general health and safety interest in protecting employees from COVID transmission so that they can be available to do their jobs. In other words, the mandatory vaccination policy could be imposed even on fully remote workers because it would just reduce the risk of them getting sick and then calling in sick to work. And the arbitrator named Michelle Flaherty did not like this argument one bit. She wrote, even if I assume without finding that unvaccinated, exclusively remote workers were at increased risk, the employer's argument must be considered with considerable caution. In essence, the employer's position is that it can prescribe activities, including medical procedures like vaccination, simply because this would increase the likelihood of an employee being available for work. It is not clear to me that the employer has a compelling health and safety interest in mandating vaccination for exclusively remote workers. because they might be more available to do their jobs. If the employer does have such an interest, arbitrator Flaherty added, quote, this is outweighed by the important interests at stake for the employees in question, including their privacy and their financial and economic interest in ongoing paid employment. So, long story short, it's only a small win because it found that people who work from home and who don't face a reasonable prospect of being forced back to work can't be required to be vaccinated. But it's also important because it rejected this idea that the employer has a general interest in your health and keeping you healthy through vaccines so that you don't call in sick to work. And like I said, this is a labor arbitration decision. It's not binding. It's not important in that legal sense, but it is important in that it sort of alerts people to the fact that they might want to insist on policies that reflect this and contracts that reflect this idea that the employer can't force you to get vaccinated just so that you don't call in sick to work. So, small victory. What do you think, Christine? Maybe we'll start with you. Any thoughts on this decision?
Yeah, so I would say to people listening to point out that this is in the specific context of a unionized workplace. So this is labor law, not employment law. So unless you're in sort of it's also not binding precedent, right? But it's also specifically in a labor context. So a lot of people I know brought claims in employment law, not necessarily unionized workplaces, so regular employment law. I have a friend, Ryan O'Connor, who's a lawyer who took a number of employment law cases about vaccine mandates and people who had been dismissed or had dealt with situations sort of similar to the one in this case, in the employment law context. And there have been a number of settlements, so we don't know what the outcome is, but I know that it's just so egregious to me that the employers were requiring people who work entirely from home to be subject to mandates like this. And the notion that your employer has like a generalized interest in your health so that you don't miss work is so wild to me. Like, are they gonna require you to eat an apple a day to keep the doctor away? Are they going to dictate your diet? Or are they going to tell you when you need to exercise and how much? I mean, obviously people should eat healthy and and exercise, but it's a personal responsibility and your health is up to you. It's not up to your employer. So the fact that the employer in this case made this argument is so dangerous to me. Super concerning. But yeah, I know that this was an issue for a really long time for a lot of people. And of course, we still have a case we are waiting on, totally different case, but related to vaccines. We had challenged the British Columbia general vaccine passport system that was applied to all members of the public. So not in an employment or labor context, just, regular citizens being required to show proof of vaccination to go about their daily lives. So we are now at 7 months since we argued that appeal. We're hoping to have a result soon. And that case was about the lack of workable medical exemptions for people who could not be vaccinated. So hopefully we'll have something on that soon. I do think that the tide of public opinion has really shifted on this issue. And now with the benefit of hindsight, we're looking back at this and saying how crazy it was at the time. Joanna, anything to add there?
Well, I agree with you on the slippery slope and one apple a day. And this is a fun little anecdote. Back in whenever it was, 2013 or whenever I was interviewing for clerkships, I interviewed with a Supreme Court of Canada judge, who I will not name. And fun fact, and a bit of a cell phone, I interviewed with 7 of the 9 Supreme Court of Canada judges, didn't get an offer. But I did get an offer from the Ontario Court of Appeal. So I was happy with that. But anyways, this particular Supreme Court judge, who will not be named, although those who know will know, told me very specifically that one of their requirements for their clerks was that the clerks had to exercise every day. And the judge said, there's a gym in the court and this is a sit down job. Law is a sit down job and I need healthy clerks. So if I extend you an offer, you have to be willing to exercise for an hour a day. And this judge was serious about it. And I am an active person by nature, so it didn't really strike me. And obviously I was just like, oh my God, Supreme Court judge. I'm like a little 25-year-old recent law graduate. But anyways, so this
You
stuff
were going
does.
to exercise anyway,
I
Joanna. Like, give
know,
me a
but
break.
but but isn't that creepy that your
It
boss would
is.
be like,
Yeah.
Joanna, get down to the basement, get on that treadmill when you're like have like 4 bench memos to write.
Yeah.
And this judge also had other requirements. What were they? Oh yeah, you needed to be reachable 24 hours a day. Like it was like if this judge put out the bat signal, you had to respond. And you couldn't be involved in anything political while you were clerking, which seems to be more reasonable. But
Yeah.
anyway, so this stuff does happen even by the so-called philosopher kings of our legal system. But I think this is a good pivot for me to talk about a less hopeful and less optimistic decision that did come out of an actual court, the BC Supreme Court, which, by the way, is confusingly named because it's really just the BC's Court of First Instance. So we got a decision this past week that BC, which has an ongoing mandate that healthcare workers have to be vaccinated against COVID-19, survived a legal challenge, although it does dovetail nicely with the results in the Canada Post case because there is a part that that was remitted for consideration that has to do with remote workers. So in this decision written by Simon Koval, it dealt with 3 separate lawsuits brought against Dr. Bonnie Henry, in her role as the PHO, Provincial Health Officer, seeking a judicial review of her most recent order regarding vaccination requirements for healthcare workers, which was issued on October 5th, 2023. Okay. And by that point, BC was and is the only province in Canada that had not lifted its vaccine mandates for healthcare workers, although there are a few hospitals in Ontario and Nova Scotia that have adopted similar rules. In BC, more than 1,800 healthcare workers lost their jobs because they chose not to be vaccinated after the initial mandates in 2021. And these were the petitioners. And the petitioners challenged the reasonableness of Bonnie Henry's orders on a few grounds. First, that COVID was no longer an immediate and significant risk as of October 2023. Second, that unvaccinated workers did not pose any greater risk to vulnerable patients than vaccinated ones, since the evidence that they led suggested that vaccines don't stop transmission or infection anymore. And then third, of course, that workers who had purely administrative positions or performed their roles remotely should have been exempt from the mandate. There were also some arguments that I'll touch on briefly under Section 2 of the Charter, the right to freedom of conscience and religion and other rights, and Section 7, the right to life, liberty, and security of the person. So this was an administrative judicial review, and everybody agreed that the standard was reasonableness. So the question was whether Bonnie Henry's orders were reasonable in light of the information available to her and the Public Health Office at the time. And the argument the petitioners made was that by continuing this mandate in 2023, the Public Health Act was using emergency powers as a quasi-permanent precautionary measure for a virus, which by that time, the Bonnie Henry herself described as no more serious than the common cold or the flu. Unfortunately, looking at the reasonableness framework, which builds in a lot of space for deference, and again, doesn't go in and weigh and sift and parse every piece of evidence, but queries whether it was reasonable at the time from the viewpoint of the public health officer to support conclusions about, in this case, unvaccinated workers posing a greater risk to patients than vaccinated ones, and about COVID continuing to pose an immediate and significant risk to public health. And the judge reviewed the evidence of one Dr. Dove, who had evidence saying that, yes, fully vaccinated people are still less likely to become infected and contribute to COVID transmission. But what I thought was interesting was that everybody agreed that conflicting evidence in and of itself. So you have one study that says, yes, it stops transmission or reduces it, and one that doesn't. But everybody agreed that just having conflicting evidence couldn't overcome a finding of reasonableness. because that's not the nature of the reasonableness review. And so because of this, I think smartly, although not successfully, the petitioners argued that the wording of the orders themselves and statements of the public health officer herself revealed that there was a lack of immediate and significant risk to public health. So they pointed to statements made throughout this period, January 2023, April 2023, where the public health officer described COVID as no more severe than other respiratory infections, even for vulnerable and immunocompromised individuals. There's a quote there that right now it's really important for people to get that booster dose to protect us from infection. And we know that the combinations we've seen mean that most people in BC are no longer at risk of severe illness and hospitalization, even in long-term care, even in people who are no longer immunocompromised. And another quote from Bonnie Henry: we've been coming out of the emergency phase. We're in a bit more of a steady state now. We still don't know about the seasonality of the virus. We have some ideas that in the winter, things will be a little bit worse. And so basically they're saying, look, you're basically saying we're imposing these vaccine mandates out of some possible future risk. And that itself is not sufficient to impose vaccine mandates, which are, again, a quasi-emergency measure. So the judge rejected this because of basically a precautionary principle, which, again, the petitioners acknowledged could apply to public health decision-making. So this is the principle that in the face of serious threats, scientific uncertainty must be resolved in favor of protecting the healthcare system. And the judge said it would be a dereliction of duty for the PHO to await the actual grips of another severe COVID-19 wave before taking steps to protect the healthcare system. And then finally, the judge did find that when it came to remote and administrative workers, that there were serious questions about whether the vaccine mandate could apply to them. The judge noted that there was an absence of evidence, complete absence of evidence. And if they say absence of evidence on the very deferential standard that we've seen so far, it means real absence of evidence regarding remote and administrative workers. There was no evidence of the specific risks they pose to the healthcare system, lack of connection between those workers and the central rationale of the orders, which was protecting vulnerable patients and the healthcare workers that care for them. So that was remitted back to public health officer for reconsideration. So this is in many ways a totally classic deferential COVID case. It's a bit retro. It reminds me of all the cases we were involved in 2020 and 2021 and 2022. And you can see really how, and we saw this pattern over and over again, that even in the face of very mainstream, credible, compelling evidence that there were some questions about assertions brought by government on whatever COVID policy, that the judge could just land their finger on one specific study. If you can find one doctor that says vaccination will reduce the chances of transmission, that will be enough to ground a finding that a government decision, or in this case, public health decision, is justified. So it's a bit frustrating. It does kind of go into the nature of reasonableness review. But I personally, reading through this decision, found the evidence that vaccination was protective against infection and transmission to be totally cherry-picked. I think it's like pretty commonly accepted now. I mean, all of us have been vaccinated and all of us have had COVID, or at least Christine and I, several times. And I know that's sort of anecdotal, but as far as I know, there's like almost no link between being vaccinated and becoming infected. Maybe there's some link still between being vaccinated and developing severe infection. But it's interesting because in terms of the Canada Post case, I take it to be a bit of a rejection of this precautionary principle, this idea that you can't just order your employees to be vaccinated to protect against some hypothetical future of calling in sick and worker absenteeism. Like, that's going too far, given that this is a serious imposition on bodily liberty. Whatever you think of vaccination, like a needle in the arm is a very directly implicates your bodily autonomy. And here, perhaps because of the healthcare context, or whatever else. The precautionary principle is allowed to cover a lot of ground. So, Josh, having read the Canada Post decision and hearing about this BC decision, what stands out to you?
I think what stands out to me when I read all of these decisions is just how, reasonableness review is so rarely going to succeed in these cases, unfortunately, because the government is basically allowed to devolve some of this decision making to individuals like, Public Health Officer Bonnie Henry, at least to a pretty wide degree. And so next time this happens, I think what really matters is that politicians need to put laws in place that set the boundaries of these things so that you can't have public health officers imposing totally unreasonable policies like this. And I just think there's one little sign of hope here, maybe, which is that people in BC a lot of them are not happy about the fact that there's like a huge nursing shortage going on nationwide, and you still have 1,800 nurses that could be working in BC that have had to like either leave the profession or leave the province. And that's having political ramifications there to some degree. The incumbent government, which is the NDP, they won 40% of the vote in the last election, and the Conservative Party there won 2%. And now they're polling almost neck and neck. And I wouldn't be surprised if this was one of the many things that has, cost them some support, right? So I think the solution to these things might be political in a lot of cases. Christine, what do you think?
So I completely agree about this evidence seeming to be cherry picked, Joanna. And I also share all of your concerns about the deferential standard of reasonableness and how unlikely it is, not just in this context, but like with the expansion of the administrative state, where so many decisions are relegated to these administrative decision makers, and then it's unlikely that courts are going to be able to overturn them. So this is it's it's not just in this context where you're assessing the reasonableness of these health mandates, but for example, I'm writing a paper right now on professional regulators and discipline for professionals who have expressed sort of controversial opinions. It's difficult when an administrator disciplines those professionals for a court to overturn it because of that deferential standard of reasonableness. Now, I mentioned in my last comment the case that we have in BC. So both of this case that Joanna just described is in BC. Our legal challenge to vaccine passports without having a workable medical exemption is also in BC. So our listeners might be wondering, what's this going to mean for our case? I would distinguish the cases. I think that they're quite different because this case Joanna just described is in the context of healthcare workers, where there's different arguments that are made about why you would want a healthcare worker to be vaccinated. Whereas our case involved the general public. It was like every person in the province was subject to these vaccine mandates. And our case also is about medical exemptions. So we were talking about people who had had an adverse reaction to the first dose and were not even able to have a second dose because they had a medical reason why they couldn't get it. And they were still being subject to this regime that required proof of vaccination, and they were not able to readily get exemptions from that regime. The government had made it basically impossible to obtain these exemptions, even though they had good faith reasons. So while I don't think the case Joanna described, I think it's a bad result, but I think it's very different from the case that we have. And I'm still optimistic about the case that we have in BC. I don't think this new case is going to change our prospects in any meaningful way. But now let's go to our break. And then when we come back, I'll talk about my news headline and we'll get to our bad legal takes. Okay, so for my news headline, I'm going to talk about the protests at McGill University and a recent injunction decision where the university had tried and failed to have those protests, removed from campus. So, as I'm sure everyone listening knows, there have been pro-Palestinian or anti-Israel protests at universities across Canada, including McGill University in Montreal. I think their protest might have been the first, if not one of the first. So, the protests include encampments that have gone on now for about 4 weeks, I think. It started at McGill on April 27th with about 20 tents, and there are now more, maybe a few dozen tents, and they're located in a large area in front of the university. They're surrounded by temporary fencing that's covered in these sort of handmade signs. And McGill has said that they have an open dialogue with the protesters who are occupying that property. The university says they've met with them 6 times between May 3rd and May 10th to try to get them to move, but they have not been successful because the protesters have a bunch of demands that the university seems unwilling, in my opinion, rightfully, unwilling to meet. Those demands are mainly that the university divest from companies with ties to Israel and cut ties with Israeli academic institutions. The university says that the encampments have disrupted the actual function of the university. They says that they say they can't use their property because of the protests, and the protests violate their own policies. And in particular, they say that the encampment has prohibited them from having their convocation ceremonies. So they had to find an alternative venue for convocation. They've relocated it to the Bell Center at a cost of $700,000. The Bell Center is the NHL arena where the Montreal Canadiens play. And McGill also argues that the encampments are unsafe for a variety of reasons. Fire and police can't access the encampment. They say that there's a risk of it escalating tensions on campus, potentially leading to violence. And I think they also have argued about the hygienic nature of the encampments, of having people like sleeping on the grass in the mud in front of the campus. So using these as a basis, McGill sought an injunction to have those protesters moved. And an injunction, for those of you listening and maybe not familiar with that term, it's a court order that usually takes the form of the court ordering someone not to do something. They prevent or restrain them from some particular act. And it's often used to protect private property. And typically the test has 3 parts, although the court in Quebec said it has 4 parts. So the 3-part test that I'm more familiar with says you must show irreparable harm, a balance of convenience in favor of the party asking for the injunction, and a serious question to be tried. The Quebec court said that it's a 4-part test. They said that it requires urgency, color of right, which is a belief that you are doing something that you have legal entitlement to do. They must show irreparable harm and a balance of convenience. So I would have thought that the court would grant McGill an injunction. It is their own private property being occupied by people who are interfering with the operation of that property. But McGill lost last week. The court denied the injunction. So I have read the decision, or a translation of the decision, which, you lose something in the translation. It's not like beautifully written. But I'll summarize it for you here. Basically, the big thing the court found was that there was no urgency in the case. The convocation had been moved already. They also said that consideration should be given to an evolution of the right to freedom of expression to include peaceful occupation. So that means that they said the issue is important and complex, and more important and complex than the type of in-depth analysis that normally is done in the context of an injunction. And they said more would be needed than they could do in an injunction motion. So the court also said that there had been no violent incidents, and that even the confrontation that had happened between protesters and counter-protesters was peaceful. And the court said that this was thanks to the intervention by the police, but also perhaps because of restraint by the protesters and counter-protesters. The court also said that the only specific event that could call for a rapid intervention by the court was the spring convocation, which had already been moved. So as a result of this, the court rejected the claim for the injunction. I think this was a mistake. I think that they should have been granted this injunction. Josh, you have written a great column recently from the National Post about these encampments. And I think that there is this notion that there is a clash between the right to freedom of expression and property rights. And this is an important analysis that I think has been missing from a lot of the dialogue about the protests so far. And it applies to this notion that the Quebec brought up of an quote evolving right to freedom of expression, including a right to peaceful occupation. And I do not think that it does include that. And that's sort of what your column is about. You wrote, Josh, in your column that it's debatable whether occupations and encampments are forms of expression that the charter protects. And you also wrote that universities might not be the type of place where the charter applies because they are private institutions. And finally, that universities enforcing property rights might not be engaged in state action, and that state action is actually what's required for the charter to apply. So on the question of whether or not an encampment is a form of expression, it is a little bit complicated. Yes, of course, there are parts of the protest that are expressive. But the seminal case on freedom of expression is called Irwin-Toy Supreme Court decision, and it did not make clear what forms of expression are protected. And you give this example, Josh, you might be expressing yourself when you punch someone in the face, but punching someone in the face is not charter protected conduct. The court in Irwin-Toy also said that day-to-day tasks like parking a car are protected if they consist of an attempt to convey meaning. And in the Irwin-Toy, they gave this example of an unmarried person who, as a part of a public protest, parks in a parking spot meant for spouses of government employees. But I think that the issue is a little bit more complicated about whether or not an encampment itself is a protected form of expression, even though there are all kinds of expressive things that are happening at a protest. The act of occupying that property, it's unclear if that's protected. So those who believe that encampments are protected are going to point to that parking example, but others are going to disagree. And really the summary here is that it is not clear cut. But the other point you make, Josh, is that it's also unclear if the charter applies to these campus quads, these properties where the encampments are taking place. And you make a pretty good case in your article in the National Post about why the charter does not apply. There's a case called City of Montreal and Numbered Company, 29521366 Quebec. And that's a Supreme Court case as well. Quebec City and Numbered Company classified that the historical or actual function of the location should be considered in deciding whether expression there is protected by the charter. And if the place is somewhere where speech is historically protected, then it probably remains protected. But if the expression is compatible with the actual function of the place, it would be protected. But if it's not compatible, it might not be. And the judges in that case noted that speech is usually not protected on private property since state action is necessary to implicate the charter. Now, it's a little complicated here because we typically think of university quads as a place for expression, but if the occupation is incompatible with use of that place, because in this case, they've had to move the convocation, then it may not be as clear cut. And finally, there's this question of whether there's state action involved. Charter protection depends on whether or not universities enforcing property rights are actually engaged in state action, which is not necessarily happening here when encampments are cleared. These are not institutions. These institutions are not part of the government, and the charter would only apply if they're doing the government's bidding, which they are not. Now, obviously, we are all civil libertarians. We do not like seeing, cops on campus with batons and riot gear. Universities, we all view as places where people can express ideas, including controversial ones, or they're supposed to be places where you can express controversial views, but it seems like they only protect certain controversial views. But I also think universities, that is their private property, and they are entitled to use their property and remove protesters who are disrupting the function of the place and who are posing risks of violence and unhygienic act and who are destroying the property. I think that they are dealing with people who are occupying and trespassing on their property. So, Josh, you sort of conclude in your National Post piece that if the university wants to enforce their private property rights, the charter might not be standing in their way. To give the court here that denied the injunction a bit of the benefit of the doubt, the court does say that it is complicated, more complicated. The right to freedom of expression may need a little bit more weighing than they can do at the injunction stage. And look, I do concede that there is that complexity here, and your article gets into some of that complexity. But overall, I do think that it's not so complex that it couldn't have been determined at the injunction stage. I do think that it could have been determined at this stage. And now McGill has been forced to spend an additional hundreds of thousands of dollars as a result of these encampments. Which, by the way, I would bet you that these encampments are going to end the day convocation is over and the campus is empty. I think that they are going to wrap up as soon as they're not disrupting anything. And you know, all of this cost of moving the convocation, ultimately that is going to be paid by the university, which is already losing money as a result of Quebec provincial laws that are hiking tuition fees for that university, only the English universities. They are already dealing with a 30% decline in applications for this university. So they're already losing money as a result of government policies. They now are being forced to spend additional hundreds of thousands of dollars as a result of these encampments. So McGill is under attack right now. There's a lot of suffering, and I do feel bad for the students there. So, Josh, I mean, I basically read your own column back to you, and it's funny because it's a column that I was very annoying in editing when you wrote it. So now I'm going to ask you what your opinion is of your own opinion piece.
Yeah,
So
yeah.
what do you think?
Oh, there's so much to say, but we only have so much time. You weren't annoying. You were very helpful editing it. It helped clarify, what our position should be on this because the law is a bit tricky. I was a little bit surprised by the injunction decision too, because all the protesters have to go on is that our occupation really is a form of protected speech, and there is some support for that idea, but I think the more likely scenario is that a court says, okay, pitching a few tents is okay. That's obviously expressive, but once it goes into like a weeks long occupation, that's not something the charter ever intended to protect. It's more like violence. And even if it were protected, you would think that the court would say, okay, well, this is, enforcing property rights is a reasonable limit on that expressive right. So it's a little bit surprising that they didn't grant the injunction. The other thing about injunctions is what I learned in law school was it all comes down to the balance of convenience. And one way to think of the balance of convenience is who's going to be more inconvenienced. Is it by if the injunction is granted or not granted? And one really easy way to look at that is, can the party who loses be compensated in money if they later win? So in this case, can McGill be compensated in money if the protesters are allowed to continue, but it's later found that they acted illegally, which is, I think, the more likely scenario here? And I think the answer to that is no. Nobody, these student groups are never going to pay McGill the $700,000 plus that they're out now, where if McGill turned out to be in the wrong, they would be able to afford to pay the protesters and compensate them in money. So on that understanding of the injunction test, I think that the decision is incorrect. But I guess we'll see. This will probably go to like a full hearing at some point. Yeah, we'll find out. Joanna, what do you think about all this?
Well, just a few quick points. So just to like make this explicit for the non-lawyers, the reason why we're so focused on things like the balance of convenience at an injunction stage is that an injunction is a remedy in advance of the legal issue being resolved on the merit, right? It's like something that needs to be decided on an expedited basis. That's why the question is like, who's going to be more hurt um, whose rights and whose interests are going to be permanently and irrevocably damaged if we make this decision now. And so I agree, looking at not just the situation on campus, where I would say students sleeping in the mud is the least of the hygienic concerns. Like, people are living there, right? Like,
Yeah, I mean, I wasn't gonna say it, but
so
yeah.
yeah. But also it almost puts the reverse onus on McGill to justify why people shouldn't be living on their campus, which is just so ass backwards. Like how did we get to this in 2024, where like the default position is, if you can claim some expressive content to your behavior, like, can somebody like post up on my balcony and I have to prove that like my rights will
I
be
know, right?
permanently, like, it's so messed up. And I feel bad for these students, as somebody who convocated from McGill on the front lawn campus, which is beautiful, in downtown Montreal twice, once for undergrad, once for law school, that they have to do this in the Bell Center, which is like a concert stadium. These are kids who already had their learning experience completely disrupted.
Yeah, it's the
by
class of
the
2020.
Yeah.
The high school class, I mean.
So I think the court sort of dismissal of that, oh, no problem, you just paid, $750,000 to rent out the Bell Center. So that's sorted. And then the last thing I'll say is, I'm not sure if this is all going to wrap up pretty quickly. As far as I know, the U of T encampment is still going on, right? I was actually just in New York this past weekend for my cousin's wedding, and I was catching up with a friend of mine who lives in Morningside Heights, close to Columbia. And I was like, well, what's going on with the encampment? And he was like, no, it's all over. Because in the US, like, when semester ends, like, they kick everyone out. I mean, just like, you can't just hang out on campus. But in Canada, people, because everybody who goes to US universities usually like lives somewhere else, right? But in Canada, people are around in the summer. So I wouldn't be surprised if this dragged out throughout the summer and you get more of these just like professional hangers-on and protester types.
I mean, that was the case at Columbia too, right? Like, we know a lot of those people were not Columbia students.
Right. But apparently it's all gone now. So I
think they're going to clear out. I think as soon as they're not bothering anyone, they're gone. Which, like, to be fair, is the point of a protest. Like, you're there to bother people.
Yeah. Well, we'll see. Anyways, should we move on to bad legal takes?
Sure. So I'll start. My bad legal take goes to freelance journalist Justin Ling, formerly of Vice in Canada Land, and briefly Maclean's, where I added him a couple of times. He also had a really good podcast called The Village, which looked at how police bungled murders in Toronto's gay village. But I'm not here to talk about that. I'm here to talk about a recent column, opinion piece he did for the Toronto Star, where he says the solution to Canada's problems, including rock bottom trust in government, is to reopen the Constitution. Ling writes, this is a long quote, "We like to say our system is a cooperative federation, a big machine that can ingest a climate crusading prime minister and a climate skeptic premier, for example, and spit out some kind of functioning policy on climate change. This is a system designed to work despite, maybe even because of, discordant politics at different levels of government. We drew up divisions of power to settle who would have the final say on these conflicts, but that system doesn't work anymore." He goes on to say that the fact that provinces have grown so hostile to federal programming that every significant federal plan now goes through years of expensive legal wrangling as the Supreme Court tries to interpret our aging constitution, blah, blah, blah. Anyway, so basically he says the constitutional division of powers is unfair and it doesn't work, and it recognizes two orders of government, federal and provincial. So First Nations are left out, and Toronto can't incur debt. Cities like Toronto can't incur debt or tax their citizens without provincial approval, and all of this is a big problem. Finally, he says the notwithstanding clause is being used, quote, just for kicks in Saskatchewan, and the charter should be amended to make it harder to use. So interestingly, Ling actually put this idea of reopening the Constitution to Trudeau in a recent interview he did. Ling was one of the very few people who got an interview with Trudeau recently when he did this sort of tour of friendly podcasts. And Trudeau told Ling, quote, "This is a non-starter." And, fact check, true, our Constitution is extremely hard to amend, and provinces aren't going to agree to any of this stuff that he's proposing. But That's not what makes it a bad legal take. What makes it a bad legal take is that the parts of the Constitution that Ling points to as the problem, as the things that are, tearing us apart, are actually the things that are keeping Canada together and that can be used to make the Federation start functioning better again. The division of powers is not outdated. Its basic logic is that the provinces that joined in Confederation gave the federal government the power to do a few things on a national level, like defense, banking, and interprovincial works and undertakings, because those things allow for, free trade between the provinces, and defense is something that we all need and benefit from, with the rest left to provinces, which are culturally and linguistically diverse and therefore, want to manage their local matters differently. As for the charter, the notwithstanding clause is a tool that can be used by provinces by those diverse cultural groups where they disagree on the extent of rights. And in that sense, even though it should be used sparingly, it's a safety valve that prevents a lot of anger from building up against the centralized government and that helps, prevent people from wanting to secede from Confederation. I'm also really not sure how, giving municipalities or First Nation governments recognition that's on the same level as provinces or the federal government would reduce squabbling. Instead of having 11 governments with constitutional status, you'd suddenly have thousands with constitutional status. And, how's that going to reduce the squabbling? I also shudder to think about how my own city council would react if it had taxing and debt powers beyond what they currently have, considering some of them are communists who literally want to nationalize all housing. And so, Justin, we appreciate your devotion to finding solutions to our political squabbles, but I think the Constitution does a lot more to keep us together than to tear us apart. So that's why you got my bad legal take this week. Christine, let's hear yours.
Okay, mine's the fun one. My bad legal take goes to Allen County Superior Court Judge Craig Bobay from Fort Wayne, Indiana. So this is an American case. It starts with in 2022, this restaurant owner named Martin Quintana. He announced his plans to open a restaurant called the Famous Taco Mexican Grill in a Fort Wayne strip mall. Sounds delicious. I would love to go there. The problem was that a local planning commission had made this agreement that the strip mall would only sell, quote, made to order or Subway style sandwiches. As a result, the planning commission said that the new Mexican grill would not be allowed because tacos and burritos, which is what the restaurant was going to sell, they said those aren't sandwiches. So the question the court had to grapple with is, what is a sandwich? An eternal debate. So Justice Bobay found that tacos and burritos are sandwiches. And he said that the planning agreement does not restrict it to only American style sandwiches, and that tacos and burritos are, quote, Mexican style sandwiches. And look, I have to say that I usually take a very, very principled approach to things, but here I am going entirely on vibes. And while I obviously like the outcome of more tacos, I just have to disagree that tacos and burritos are sandwiches. I don't think I can accept that. And I don't have a good reason, but let me try to work through it a little. I think a sandwich requires bread. And if we're going to do this analytically, we have to ask, what is bread? So I looked up bread in the dictionary, and Merriam-Webster defines bread as, quote, a usually baked and leavened food whose basic constituent is flour and meal. So this does not really help us because it says usually. So I don't know. Cornmeal and water, I guess it could be bread. Flour and water without yeast, I guess it could be bread. Cornbread does not have yeast, but we call it cornbread. Is a biscuit sandwich a sandwich? I don't know. I am confused. The judge in this case said that a banh mi is a sandwich. And like, that's not even an edge case. It's on
It's
a French
obvious.
baguette. He said heroes are sandwiches. I don't know. I don't think so. Like I would call that a wrap. Same with a burrito. So apparently the CRA, the Canada Revenue Agency, considers tacos and burritos to be sandwiches because it says flour and corn tortillas are bread. I don't think they are. I think that they're tortillas. So this maybe it's, eternal debate. And while I appreciate Judge Bobe allowing the tacos and burritos, because look, sometimes I just care about outcomes. But I just don't think I can concede that these are sandwiches. And my reason is I said so. So if you're watching this on YouTube, you can leave a comment. Are taco sandwiches, are burrito sandwiches? What is bread? Help me. I don't know what's going on. I'm confused. So that's my bad legal take. Maybe it's my own take is bad. Maybe Bobe's take is bad. I don't know.
That is the stupidest legal take we've ever done, but I'm here for it.
I want a taco now.
I think you need 2 slices of bread. It's not just bread. You need 2.
No,
true.
no,
2 pieces
open
of
face
bread.
sandwiches are a thing.
That's
And
an
what about
exception
a
to the rule.
club sandwich, 3 slices of bread?
No,
Oh, true.
it doesn't
Okay.
work. I remember in my philosophy 101 class, we had a conversation about how to define a salad. And it's well, there's leaves. What about pasta salad? What about tuna salad? It's very difficult to define.
Russian salads are just a bunch of meat in a bowl with mayonnaise.
Yeah. Well, that's pushing it.
I mean,
Yeah.
tuna sandwich or tuna salad is just tuna
That's not a
fish.
salad. Okay, let's move on.
Okay.
We're the worst at statutory interpretation, apparently.
Okay, my bad legal take of the week goes to a judge in Ottawa, Justice Mark Smith, who has ruled in favor of Ottawa taxi drivers in their $215 million class action lawsuit against the city of Ottawa, alleging that the city abandoned them when Uber arrived in the city in 2014. And the judge found the city negligent in failing to enforce its own bylaws to restrict bandit cabs, aka Ubers, from operations, and capitulating to Uber's bullying tactics when it entered the Ottawa market. He wrote that the city adopted a defeatist approach to Uber's entry into the Ottawa market. A multinational giant was invading Ottawa, and because the city was unprepared and its lack of efforts to develop a plan, the city's enforcement efforts against Uber drivers were ineffective. He said the city ignored warnings from the taxi industry about what would happen when Uber began operations. And as a result, the city was caught flat-footed when the ride-sharing service appeared. So this is a bad decision. This is alleging that Ottawa had a duty to act as a sort of cartel thug protecting the taxi industry against the clearly demonstrated consumer preferences of both Ottawans and pretty much the world over for ride sharing and Uber driving. It's really hard for me to see how the city could, in legal terms, be proven to have shown to have caused the loss to taxi drivers and their licenses, instead of, again, just the evolution of technology and clear demonstrated consumer preference. In New York, a similar claim, New York State, a similar claim was recently found to not be justiciable. The New York Court of Appeals held a few months ago that the city's taxi commission never promised yellow cab companies that it would take steps indefinitely to protect the value of their licenses, known as medallions, which are worth millions of dollars. I do have a lot of compassion for taxi drivers who lost the value of their licenses or medallions, but I also have a lot of faith in them as human beings who are endowed with reason and ingenuity to continue on into the future. I remember we were at a conference a year or two ago that had a small Liberty-themed film festival, and the group from Australia did a short clip that was showing horse and buggy industry arguing to preserve the rights of horse and buggy drivers. That's just not how the world works. Bad legal take, Justice Smith.
I think that is how the world works when it comes to legacy media, but we don't need to get into that. Anyway, as usual, we hope you will rate us, review us, and subscribe. And I really do mean go rate us and review us, because that helps us to find new listeners. And just a reminder, you can support our work by subscribing to the CCF's YouTube channel, to the Not Reserving Judgment channel on YouTube, or by visiting our website, theccf.ca, where you can sign up for our Freedom Update newsletter. The CCF is a nonpartisan legal charity funded by your donation, so please click that donate button on our website if you can. Thanks for listening.